Good enough. You want to throw a couple others in? Go for it.
Order, rise. Court is now back in session. You may be seated.
This is 23 CR 91, the Commonwealth versus Brian Walsh. Can I have counsel identify themselves, starting with the Commonwealth?
Good afternoon, Your Honor. Greg Conner from Commonwealth.
Good afternoon, Your Honor. Laura McLaughlin from Commonwealth.
Good afternoon, Your Honor. Good afternoon, everyone. Kelly Ford is on behalf of Mr. Walsh.
Good afternoon to lawyers and good afternoon to the defendant. So happy to see everyone, and I'm going to go through what I have on my agenda, and then I'll address with you whatever, if I can, address with you whatever questions you have. On my agenda today is to talk about the pending discovery disputes, see if we can make some forward progress on that today, either today in the hearing or if not, in ruling in the near future. I want to discuss the scheduling order and where I see this case going in terms of progressing forward and discuss your joint motion that you submitted last week, and the preview for that. I guess I don't see this case going into 2026 for a trial. I think it should be tried in 2025. I'm certainly going to do my part to make sure that it keeps on track to get us there. And that's due to, in large part, the age of the case and its respective complexity, or not, and the range of cases like it. So I think that it's reasonable to assume that a case such as this one will be tried within 2 years. Indictment on the present schedule we're looking there that you suggest, I think it's coming closer to the 3-year mark, and I think that's a little unnecessary. And nothing gets better with time. People's memories don't get any better, and the case isn't going to get any stronger. People's memories fade over time, and so I've been interested in making sure the case gets tried as efficiently as is possible, respecting the numerous issues that have to be addressed. So we'll talk about that, and then I think attenuate to the motions that have been filed. We're going to need another date, or perhaps need another date on the Rule 17 motions, which I appreciate the defense filed to come up, I assume, based on your earlier pleadings, and third parties may be filing objections to those, so we'll get that on the calendar. With regard to the calendar, I'm happy to come down here today. As you know, I have been specially assigned. I want you to know when we're picking dates for future things that it's highly likely you're going to be traveling. I'll try to travel here when I can, because I know that this is where it is. But you should also build in the expectation that you may be traveling, and the travel in the next 3 months is going to be to Middlesex County, because that's where I'm going to be assigned for the first quarter, deliberately not far from here, recognizing that I probably would be seeing you a bit between now and whenever we get the case ready for a tee up for trial. So let me say that, just so that you sort of have an idea of what my knowledge base is, and I've gone back and tried to listen to a number of the hearings on the case, most notably, I guess most importantly, your last hearing before Judge Cannoni, when this issue with regard to, I think as Attorney Tipton said, it was an exhaustive or extensive discovery request came up, and you all thought that you could make some headway, and you did make some headway, although there's some disputes that still linger. At that time, so I listened to that last hearing. I also went back and listened to a hearing on June 24th, in which we were first the parties informed the court that the trial date was too tentative at that point, at least 6 months ago anyway. I have before me now what are the first round of discovery disputes. Those were docketed, just for the record, and as paper number 18, the defendant's motion for discovery of documents related to the district attorney and law enforcement. That then gets updated by your second motion, which I got to be filed on Friday. That's paper number 32. I've gone through those. I've gone through the Commonwealth's oppositions to those. And then also, I received on Friday paper number 31, which is, I'll call it the federal investigation motion, and the Commonwealth's opposition to that, which I just briefly, I got it just as I was coming down the stairways, and I read it, but I haven't given it much thought. The first thing I wrote before I got your opposition was do a TUI request. And so I see that at the end of that, that's exactly what we're doing. We'll get to that in a minute. So I've read all the pleadings. I have looked at some of the law that I want to look at. There's one thing that I didn't get a chance to look at this morning, but I'll hear from you. And perhaps the best way to do it is to just go item by item and identify. I think it pretty clearly now identifies where there's a variance. If you wish to be heard on any of the orally, I'll certainly give you the opportunity to do that now. If you want to rest on the paper, so that's fine too. I may have questions as we go through them. But why don't we all just turn to paper number 32 and go through those now.
Would you like me to start?
Sure.
I think by and large, I'll just rely on this plea that we filed after the Commonwealth and the defense sat down on a number of occasions and worked through this. By and large, Judge, what we're asking, just turning to page 2, paragraph 1, subparagraph A.
Yes.
We continue to ask for disclosure. I understand the reality of this is that they've engaged an attorney who I am familiar with professionally, and like I say in our motion, we don't object to Attorney Sack being assigned to review. So we have no objection to him, and I'm not familiar with Jim Carney, but I have no objection to Jim Carney. It's just that we believe, based on the existing case law, and the citations that I've provided in the memorandum, that defense counsel is in the best position to assess the exculpatory nature and the utility of this information, whether it impacts bias, credibility, or the Bowden defense of the conduct of the investigation. And for those reasons, and I'll leave it at that, we ask that this material that the Commonwealth declines to turn over be turned over. Other than that, that's all I'd have to say on that particular issue.
Comment?
So, Your Honor, I can tell you that not only did we retain Attorney Sack, and he's received the download of the phone, I am also going through the phone through all of the emails and all of the text messages and anything that could be a statement to try and find Brady material, but I'm also focusing in on Rule 14 statements, and I feel it's my duty under Graham and McFarland to go through this myself and find anything that could be potential bias, but also statements, and I'm doing that. I've focused in on all
I'm happy to hear that, because you'll find that I try to be as transparent as I can to both sides. And when I read this, I don't know Attorney Sachs, and I don't know the computer person either, but this is interesting. Commonwealth gets to delegate its responsibility to review the materials. The defense isn't objecting to it, but I have seen special ADAs, special prosecutors assigned to a case, but I've never seen a third party that's responsible for that. And my initial response, honestly, was, I don't think they can do that. I don't think they can delegate that responsibility to an attorney. it sounds like you've got belt and suspenders. You're doing it yourself, and it's a backstop or a double check.
Yes, Your Honor.
For the consultant attorney.
That's the purpose of attorney staff.
All
It's
right.
not to outsource it, but to double check what the Commonwealth has done.
Okay.
And he's doing it independently.
All right, that's always good to have another set of eyes, I suppose.
Yes, Your Honor.
All right, anything else that you want to talk about with regard to this beyond what's in the papers?
Not beyond what's in the papers, Your Honor. We pointed out that there's sensitive material in there about ongoing investigations. Turn over the phone to Walshe would be problematic and could jeopardize ongoing investigations. And as a result, that's one of the key issues of why we can't turn over the phone to Walshe.
By the way, what I'm probably going to do is following this hearing is I'm going to give you an omnibus order on discovery. I'm going to follow your sort of how you set up the issues because it makes sense. And so I'll just go one, A, B, C. It makes sense. And I'll probably be doing that more quickly than I thought it was going to be. My trial was supposed to start tomorrow, just tanked on me. So I'll have an opportunity to look at this. While it's fresh in my mind, I'll get something out to you.
Yes, Your Honor.
I will tell you that preliminary view on this is that it's the Commonwealth's obligation, and that nothing that has happened or that I've read so far turns that on its head. And the idea here that I understand that the defense has a very unique perspective on every piece of evidence that is just a different view than a prosecutor in the case is going to have. But in some ways, I feel like you're inviting me to rewrite the obligations of Rule 14, and I'm not prepared to do that right now based on the information that I know. But that's just my preliminary view, and I want to give some more thought to the arguments that have been made. All right?
May I proceed? Are you done?
Yes, please.
With regards to paragraph number 2, the request regarding the 3074 pages, I will defer to Attorney Kelly Porges, who at the time we finish this motion, she'll be arguing the motion that addresses that request, I think.
Okay, that's the motion paper number 31.
Yes.
I'll defer on that one.
We don't need to touch upon paragraph 3. We're waiting for production of those letters. Paragraph 4, we don't need to address because we're withdrawing that at this time.
Right.
Regarding paragraph 6 is really subsumed in Rule 17, and we'll deal with it.
5 is not an issue either, right?
5 is not an issue. I'm sorry.
Okay.
And once again, paragraph 7, that's assumed in the Rule 17 request, I do believe. Number 8, we all agree, at least the Commonwealth and we agree that that's captured in paragraph number 5, the request 5, and we'll need to deal with it. Moving ahead through now to request number 14. What we're trying to do is say that, argue that the Commonwealth needs to produce this unless it can make a sufficient showing of what it characterizes as the basis of its argument, that what we're asking for implicates the work product rule. And where I would agree that if the work product rule under 14A5 is in fact implicated, I understand that they would have grounds to say they can't disclose it. But I find it hard to believe that what we're asking for, that the entire universe is captured as work product. And so for those reasons, we ask that that request be allowed in so much as what we've asked for, that they
Why
have not
isn't a
agreed.
good initial step to just say, have them, we commonly see this in civil litigation, but go through, and it's perfectly appropriate for criminal litigation as well, to go through and say, this is the basis for the work, this is, the privilege law, and at least give the defense then the universe of what the responsive documents are, and if it is the Commonwealth's position that they're covered by the work product privilege, there'll be enough information that you can make everybody can make some preliminary assessments. And if there are some that still can't get to yes and figure it out through that long, I may then entertain looking at them myself, but I don't think that that's necessary as a first step. What's the Commonwealth's view with regard to privilege law?
Your Honor, there are some items that would be distinctly privileged that we would have the burden to show. That being said, the Commonwealth is producing any and all notes written by any of the officers, investigators in this case,
I saw that.
and reaching out to, we've also produced any and all notes and reports from the crime lab. I'm reaching out to OCME to see if they have any additional notes. So the only notes that I can think of that aren't being produced would be mine. And
Okay.
and my notes would be on scheduling, strategy, theories, thoughts on the case. And so at this point in time, those would be worked on.
All right. Do you have any objection to putting those in a law?
I would, yes, Your Honor. I
Why?
would. Well, because I
I mean, all I'm asking you is from the date, if you have it on your notes. If it's an internal note to yourself, that's it. Internal note, 88 Connor. Date. I'm not asking you what's in there. You can say,
it's
you
just
can
not
say
how-
as blandly as trial strategy, if that's what it is.
Well, my notes might not reflect dates so much as where I am sitting at my desk writing down theories. So the best I could do would be to say,
You're not asking for that, Attorney Tipton, right? You don't want to.
so I will go through my notes and see if there is anything that would be discoverable under Rule 14. But as of right now, I can't think of anything, but I will double check, and if it gets to the point that I have to create a log, I will. But I will see if there's anything that contains a statement under 14.
All right, if there's any, if this is a series of notes, it seems like an exercise in futility for you to have them do the log. I'm just saying, if there's something more complicated or complex than that, because I'm clearly not giving, you don't want them, you're not going to get them. So if there's something more than your notes, something going back and forth that reveals strategy, perhaps with you and the investigators, I'm not going to have you produce that either. But he wants a record, and he's having Attorney Tipton's, credibly saying that he doesn't think that that's the whole universe of what would be out there. It may be.
And so, Your Honor, if we're talking about communications, separate from notes, like I said, I'm going through the emails and text messages that are in the phone. And if there is anything in there that's discoverable under Rule 14 as far as a statement of the witness, that's going to be turned over.
Sure.
I intend to be as liberal as possible, understanding what could be 14. But if there is something in there that is trial strategy, and I think that it could get to that point, we're talking about statements in the phone, then I would create a law.
Okay.
I would create a law, because that it seems like the appropriate way. If we're talking about the phone itself, but when I say the phone, I'm talking about Michael Proctor's work phone.
Right.
I'm not looking to go through every person's phone. I have no knowledge of what is in every other person's phone. But Mr. Proctor's phone is distinctly in the custody and control right now, or the download of it of the district attorney's office.
Okay. All right. So with regard to that, let me finish by saying, any notes, and you'll see this in the omnibus order, any notes that are internal notes to the prosecutor, I don't need to see that on the privilege log. If you want to revisit that, Attorney Tipton, you'll let me know. If there's something that comes up in the course of your review of the phone that is of the sort, I know it varies a little bit off of what we're talking about right now in this particular request, start making a privilege log.
Yes, sir.
And obviously share it as it's being updated.
Yes, Your Honor.
Okay? All right.
Focusing our attention on both paragraphs 15 and 16, I think I can just argue these both together.
Sure.
And the gist of this is our request is because the Commonwealth has said they are not in possession of anything and any knowledge at this point, my subparagraph F, really what we're asking for then is to make sure that the Commonwealth, in an affirmative fashion, requests cellular records and text records of the Cohasset police that would impact and bear upon bias, credibility, or the investigation. And I say that because without an inquiry by the Commonwealth of its agents, that being the Cohasset Police, we really have no way of seeking this type of information. But more important than that, that given what we now know about what has and may have occurred within the ranks of the Mass State Police assigned to the District Attorney's Office, and I'll just add, without trying to sound hyperbolic about it, but in the Boston Globe today, there was yet another report talking about the failings, if you will, of the Mass State Police in the way it disciplines its officers, and the way that certain officers, at least one, was promoted even after significant complaints were made. I think to fulfill McFarland and Graham and the requirement of Mass Rule Criminal Procedure 14A3, that the Commonwealth should be required to inquire specifically whether the Cohasset Police have checked, and I'm not talking about all the police officers, I'm talking about the Cohasset Police, and there's 3 primary officers involved in the investigation of Mr. Walshe, to see if they have anything that comports with, and who knows if they would disclose it, but I would hope they would, comports with text messages and emails and cellular phone records that indicate a bias, a prejudice, and a lack of professional integrity when it comes to investigating Mr. Walshe. And I will say that it was the Cohasset Police, and I'm not casting aspersions on the Cohasset Police. I'm just saying that if it's out there, the only way to really get to the bottom of it is if the Commonwealth fulfills its duty of inquiry and then returns back and tells us. I leave it at that.
Who are the 3 Cohasset police officers you speak of?
Mr. Schmidt, Lopes, and the third name is eluding me right now.
Any comment?
Well,
On the third name? Or
I would suggest that Harrison Schmidt and Anthony Lopes were the lead investigators for the Cohasset Police Department. Several Cohasset police officers did aid and help. So there, if you were to say that there was like a B team that was helping with the initial investigation, that would be more than just those 2 officers. But Lieutenant Lopes went to Washington, D.C. and did some investigation, and Sergeant Schmidt has been the case officer for the Cohasset Police Department. So, Your Honor, as far as a duty to inquire, I am happy to inquire of the Cohasset Police and the state police investigators to see if there are any statements in text messages or emails that fall under 14 or are exculpatory, for instance, under Brady, McFarland, and Grant. I'm prepared to do that. That being said, cellular records is a bit more of a problem because I don't think a cellular record, whether it be a call detail record, would necessarily show anything. It would show maybe a call takes place, but I can't tell you that that call is about the Walshe matter.
Well, and that's what I wrote in my notes next to see is how would a telephone record tell you whether it related to this case or not?
Let me just apologize for being unclear about that. I should have been much more specific. I really wasn't looking for phone logs or anything. I was looking for something that was contained on their cellular phones, such as whether it be emails or text messages, or the written word that would be indicative of bias and credibility issues. I am not interested in, at this point, of looking at phone logs, and I apologize for not being more clear about that.
So with that, I would inquire of the officers.
All right. We have agreement.
Yes, Your Honor.
Okay.
Moving along, number 17, we withdraw
Yes.
as we continue. Number 18. And once again, if I could just point the court's attention and the Commonwealth to subparagraph G. That is G. That's one of the most inartful sentences I've ever
I
drafted.
don't want to hear what I wrote next to that.
Probably you said something a lot more stern than inartful, but it's what it was meaning, what it was meant to convey was that I'm sure the government is aware of the fact if something in their possession was destroyed or altered, and they would tell us that. I've been working with this DA's office for 2 decades.
Right.
So when I read that this morning in preparing, I cringed because it suggests that they're unaware of their own mistakes. And
That's how I read it.
What I was trying to say was, when they respond that they're unaware of anything being destroyed or altered, at least by their office, I take that at their word, and I understand that. So what we're saying, though, is, once again, a duty of inquiry, and a very specific inquiry of its agents to find out if anyone else is aware of something being lost, destroyed, or altered by way of, whatever that is, if it has to do with the investigation of Mr. Walsh. And I think a duty of inquiry is required under the facts and circumstances, and what history has told us now, the recent history of the conduct of some officers involved in the investigation of this case. And so that's really what we're asking for, just an inquiry at this stage to make sure that there is an affirmative statement on the record that after inquiry there's no knowledge of anything being altered, destroyed, or corrupted.
Okay.
I appreciate Mr. Tipton, his honesty on paragraph G, because I was confused as well. Because when it comes down to it, is at this point in time, I don't know if something is lost or destroyed. So if I find out, that would be exculpatory, and under the rules, I would have to tell him. So I would tell him. I guess what Mr. Tipton is asking me to do is to actively go and ask every officer if anything is lost or destroyed. When I do my inquiry, I will ask if anything is lost or destroyed.
Sounds reasonable. Okay.
I think that's it for that.
That was faster than I thought. All right. Do we want to address April 31 and whatever the Commonwealth's been docketed as the next entry, which is the, I'll call it the 2-8 appointment. Now that the defense has seen what the Commonwealth intends to do, is that, I mean, that seems to me the way that we get the information, if they're going to get the information.
Respectfully, Your Honor, they have the information. The information is in the custody of the Norfolk County District Attorney's Office, so not only is 2E unnecessary, it would still be premature when you look at the cases such as Donahue and Lehman.
What if I'm not persuaded by your argument that I ought to be persuaded by this Rahim case, which I frankly am not persuaded by?
So the first question is whether or not the documents are under the purview of Rule 14. We believe they are. We're kind of at a disadvantage because, one, we don't have a copy of the protective order or the non-disclosure agreement. So we're at a loss there because I can't specifically articulate what exactly the protective order is, what exactly it covers, and 2, we can't even articulate what is in these materials. The importance of Rahim is that if it is physically in their custody, then they have received it. It is in their control. They possess it. Just because a federal agency says, no, it's really ours, it's not theirs to give.
That was very much so in the context of a joint investigation, right?
It was, Your Honor, but in this case, the government, the federal government and the Norfolk County District Attorney's Office were essentially working together. They were working to investigate a homicide that Norfolk was prosecuting. They were investigating the state police for integrity violations, policy violations, inappropriate conduct, failure to supervise. And so this information has been starting to get turned over to us, and as Mr. Tipton articulated, whether it comes to Bowden or credibility or bias, That's part of what we want to show and what we expect to show. So we believe the material is Rule 14. They have it, ergo we should get it. So I don't think 2E is even necessary yet. If they've indicated they're going to take that road, then that's fine, but that does not negate our argument that it is Rule 14. And the SJC, as recent as 2020, has clearly stated that it is in their possession. With respect to the cases they cited in their response, they're relying on Como versus Bonnet, which was a 2015 case. I don't believe that's on point. Bonnet is a case in which the state district attorney's office was not aware of the identity of a confidential informant. And so it wasn't in their custody. And secondly, they were saying that it was privileged. We have nothing to show that anything in those 3,074 pages are privileged or protected. We don't know. We've pulled it together from pleadings from other cases, responses from the government, just to know that they have it, roughly what it's about, and then several letters between the district attorney's office and the federal government talking about this material, specifically the officers involved. And the reason I can point to, there's a myriad of reasons why it would be relevant, but what we're able to determine is that Trooper Proctor, who was the lead investigator on this case, the moment he stepped foot into investigating Brian Walshe and the disappearance of his wife, he knew he was under federal investigation. And so his bias, his motive, anything or his integrity is forefront for him. So with all those thoughts, when you're considering all of that, I don't know how it's not Rule 14. I don't know how we're not already in possession of this. And so otherwise I rest on the papers. And they talk about Beal, your argument. In Beal, I agree the prosecutor doesn't have a duty to go investigate our case, but they have it. So we're not asking them to go get something they don't have. And in footnote 4 in Beal, which is cited in their brief, it specifically says the government isn't able to simply put their head in the sand if there is something exculpatory. And documents that show that the lead investigator in a homicide case knew he was under federal investigation the moment he stepped foot in the case is certainly...
Isn't it even stronger? Well, I'm not making your argument, but wasn't he already under prosecution?
No, Your Honor. Do you mean
So
Mr.
what's the
Walsh, or
yes.
do you mean... No.
What's the timing of his federal indictment?
Do you mean do you mean Trooper Proctor or Mr. Walsh?
I thought you were talking about Mr. Walsh.
No,
that
Mr.
there's a
Walsh
bias
is
because he
state
knew that
investigation. No, Trooper Proctor knew he was under federal investigation. The moment he
I thought you were
stepped
saying there was a bias against your client
No.
because he was under
No.
federal eye.
No, it's Trooper Proctor.
That's an additional bias, by the way.
Right, but we're just focused on that part. But the moment he stepped into this investigation, and bear in mind, the Norfolk County District Attorney's Office, they control homicide investigations. They work with the state police with CPAC. So now the Norfolk County District Attorney's Office knew that Proctor was under federal investigation, specifically for how he investigates supervision, etc. He now is the case officer in this matter while his case is pending. So that's one of the myriad reasons why not only are these documents relevant, they could very well be exculpatory. And under Rule 14, it's not exculpatory, it's material and relevant. And so with respect to that, I would rest on the papers, Your Honor.
All right.
So, Your Honor, it's my understanding that the federal government has never said that they were investigating officers. That's never been a public statement by the U.S. Attorney's Office in this matter. They have released information to the Karen Reed prosecutors that was subject to a federal protective order signed by a judge that is impounded that I can't see. I have also not seen the materials that were turned over to the Karen Reed prosecution team. So I don't know what's in those materials either. I can tell you that I watched a large portion of the Karen Reed trial, and from what I could see, 2 witnesses identified that they had testified in a federal grand jury in that case, when they were testifying in the state Karen Reed trial. It's further my understanding that the federal government acknowledged that they were investigating the death of John O'Keefe, not the district attorney's office and not the state police. It's also my understanding that the U.S. Attorney's Office has not said that this investigation is done.
They never do.
They never do. I can say, Your Honor, I have no knowledge of anyone receiving a target warning. As far as being a state trooper, the district attorney's office, Canton Police Department, any civilian witnesses, I have received no knowledge of anyone receiving a target warning. And I would suggest that this is premature, that I have filed a TUI request with the U.S. Attorney's Office for the Walshe materials. I told counsel today I think I should file a TUI request for the Karen Reed materials. And I was willing to work with counsel to make it a joint request. I can understand if they want to do their own, but that would be my suggestion, because I would suggest under ALEA, we haven't gotten to the point of the need for the court to become involved in order discovery to be turned over. Particularly discovery that if it was turned over, the people who have seen it would be a violation of a federal non-disclosure. So I'm not prepared to have someone from my office be charged with contempt. I would prefer that we go down the road of trying to work with the U.S. Attorney's Office and see what those results are, report back to the court, and let the court know.
All right. I'll take a look at the cases that both sides have cited, and I'll include whatever my decision is with regard to that in the omnibus order as well.
And one last point, I don't think we can say that the U.S. Attorney's Office and the state police work together on this investigation in the matter of John O'Keefe. It looks like it has been completely two different agencies doing two different investigations. I don't see any, there has been no sharing of information until there was discovery turned over to the Karen Reed trial.
Well, Your Honor, it's not, the case law isn't just about specifically whether or not they worked on this case together, but if there is cooperation in general between the two agencies, which clearly there is. And the problem is, there's too much we don't know we think. I don't think it's, respectfully to Mr. Connor, I understand he's willing to make the TUI request, but I don't know how we say we're going to make a TUI request, which when you send a letter to the U.S. Attorney's Office saying we believe you have relevant material information, and then at the same time object to the Rule 14 of materials in their custody. That's no foreign deal on point. You can't put your head in the sand. I don't think it's right to be like, well, someone else in my office knows, but I'm just not going to talk to them about it. I understand if there's protective orders and if the government wants to rely on that at this point, but I think that not only is there evidence that these two agencies routinely do work together, I think the fact that the officers involved in both cases were under investigation for whether it's integrity, investigation, failure to supervise, I think that does count as working together for this case as well.
I would just disagree with that.
All right.
If I may, Judge, just briefly, I don't want to step on anybody's toes here, but when Mr. Connors just said that we didn't want to work with him, I will say we will work with him. I just don't want, and Attorney Porges don't want, that our efforts to work with the Commonwealth dilutes our Rule 14 argument. That's all.
We get the lower hanging fruit. The Rule 17, when do you want to schedule that?
I reached out to Chief Legal Counsel for the State Police. They asked for 4 weeks.
Okay.
So with
What does that bring us to?
4 weeks would bring us to the beginning of January, first week of January specifically. January 6th through the 10th.
I'm available.
All right. So, I want to get a date on the calendar, and recognizing you're likely going to be up and moving for that one.
Yes, Your Honor.
And so I just want you to know that in advance. I'm happy to do what I typically do, and frankly what I'll be doing when we try this case or whatever that is. I try cases from 9 to 4. And what I do to accommodate the other business, depending on the length of the case, is try to go on the bench at 1:45 and clear away the more straightforward matters, and frankly put off the more substantial matters to a time when you're not on trial. And the goal there is to keep the case moving and to be as most respectful, frankly, as I can to the jurors who are making a big commitment of their personal time. So it becomes a little bit of a juggling act, but it's doable. You just do it for the 2 weeks. This feels like a 2 to 3 week trial for me. You're going to tell me later on down the line what it really is, but just on the limited knowledge I know, 9 to 4, Monday through Friday, it feels like 2 weeks, but I don't know enough about the science yet.
We're anticipating 4 weeks, and
On a full day schedule.
on a full day schedule. We were just talking about that before we came.
You're probably right. It doesn't feel that way to me, but that's only because you know a lot more about the case than I do.
We also know each other. We've done a lot of things with each other as far as trial work, and we know that neither one of us kind of waste each other's time. So we just believe that we're probably in that realm. We also think that impanelment will take 5.
And that my estimate was after we get the impanelment, which could be 1.
I was trying to include impanelment, so I think that if you're thinking about testimony, it's probably about 3 weeks.
So it feels like.
Yeah.
But again, your estimates, I'm going to take your estimate to the bank because I'm just entering the case and you know so much more than I do about what it's going to take to try the case.
Yes, sure.
So, but that's important and it's a good segue. Anyway, let's get to, the reason I mentioned that scheduling issue is I can see you at 9 o'clock in the morning if you want to do that, and I'll just delay my trial on that day till 9:30 or 10 if that works. If you don't like that, and I get that because you're going to have to deal with a 120 in traffic going up there, which is not good. I could see you at 1:45, and I'll give you 1:45 to 2:15. Or I could see you at the end of the day. Pick your time slot.
Whatever works for Mr. Tippett, I'm happy to do it.
The 145 certainly works for me.
All right, let's do the 1:45.
Which day?
Any day, but Wednesday or Thursday or Friday that week would be best because the panel on the case alone is probably going to take a couple of days.
How about January 9th, which is the Thursday?
That's the one date I couldn't do that. Sorry.
So I picked it. How about the 8th?
January.
January the 8th.
At 1:45 in
Wednesday?
Yes. And if the defendant wants to be there, obviously we can get him there. If you want to waive his presence for that, that's fine too. You just let the court clerk know and each other.
And just so the record's clear, I do have a manslaughter case scheduled for trial for January 7th, but I'm probably going to learn within the next few days if that's going to go or not, but I don't anticipate it going. I just want to...
Okay. If it is, we'll find another. I just want to keep everything moving to the best that we can, but and I will be agreeable. You're on trial, given the nature of this dispute. Also seeing you on Zoom. So, given the nature of it, the dispute, I don't know that we all have to be physically in the same room. I prefer that, but it certainly isn't necessary to get your points across.
Thank you, Jim.
All right. But right now we'll presumptively say 1/8/25 at 1:45 in Middlesex, and I'm going to be in Middlesex 5:30, I believe. Definitely on the 5th floor.
Oh, okay.
All right. So let me move to the schedule. Let me see if I can find proposed scheduling order. Every judge has pet peeves. We all do. You do too. Your own pet peeves or your practice. One of my pet peeves is serial motions to suppress. I like to do them all at once. I never understood why you have a motion to suppress this, that, and the other thing. Just do it all together. Evidentiary, non-evidentiary, put it all together. So I want one date for the motions to suppress. Or put it all into, break it out if you want to break it out. But it's all going to be argued and heard on the same day. And so that's going to compress the schedule. The other question that I had about, and these are just general observations when I looked at your joint motion, is there's a for a relatively brief period of time, as you have it scheduled right now, between the motion to dismiss and the motion to suppress. So in my judge mind, I read one of two things. I don't think one is really coming and it's not going to change the schedule. Or there is one coming and obviously we're setting ourselves up for, we're not going to even get to the April date. So those are the thoughts that are running through my head. This case ought to try in 2025. I think we should pick a trial date in around a year from now. Now that you're telling me it's 4 weeks, I'm much more likely to look to November as opposed to sort of when I was driving down here, I thought first week of December we'll get this in before the end of the year. We might. Maybe somebody could take a look at the calendar and see when Thanksgiving is. Maybe we do the Monday after Thanksgiving. I think we'll get it in 4 weeks, clearly there. But I think that kind of schedule should give you a reasonable amount of time to get the work on the important work that you need to get done. But keeps this case on a little tighter schedule. It's going to be, as I said, I think the case was arraigned in April 27th of 2023. So I guess the suggested time that I'm giving you is 2.5 years. That seems like enough time. Now, I've said it a couple of times, I'm going to repeat it again, and I'll certainly hear you. You know the case better. When I see things in motions that say there's 27,000 pages of documents in this case, what does that really mean? I don't know, because I don't know what's in those 27,000 pages. Not all 27,000 pages are the same. You know what I'm talking about. And I don't know how much more is coming. But you can compare it to other cases tried here and certainly elsewhere in the Commonwealth and say 2.5 years, it's time to go. And that's what I'm suggesting. So I'll hear from both of you. Who wants to go first?
Well, Your Honor, I can say that as far as the discovery goes, it went in a couple different directions being the grand jury, which was about 1,000 pages, but I think it was a complicated case as far as pulling it together because there was a significant white-collar portion to it. So with that, I understood how the discovery got up to there in numbers, but that being said, Mr. Tipton and I have had a long-standing relationship and working on cases together against each other, and I think that we have a really strong relationship on trying to get to the heart of the issues. We talked about trying this case in 2025, and we were looking at potentially late October, and I'm looking at the calendar right now in front of me, and I think October 20th, 21st is the second to last week in October. To me, that gives us about a month before Thanksgiving, which is a nice target. I think it also makes it easier to get panel jurors. I think once you start crossing towards holidays, it becomes a little bit more problematic. So that would be my suggestion as far as the trial.
And just so you know, that's 6 weeks before Thanksgiving. That date you just picked.
October 20th, 6 weeks before Thanksgiving.
Yeah,
Late
Thanksgiving is again a late one, it's November 27th.
So that's, given impanelment being a long time, could be like over 5 days, could be 7 days, I don't know. I think that gives us enough time.
After talking with the district attorney and our client,
If that date is good for you, it's good for me.
That's right.
Do you want to work backwards or do you want
Is it gonna be
It's not mine.
someone's media box has a phone or some device that's vibrating, so if we could shut that off, that'd be great.
I think it's stopped now. So. All right.
do we want to work backwards?
Yes, we're going to work backwards right now. So what was the date that you just said?
So October 21st, Tuesday, October 21st.
Okay.
if I could,
I just want to add, does anybody want me to ask Civil, do we want to start on the 20th?
Might be a good idea.
Yes, please. It's been a few years since I sat here, so it's,
Yeah.
what is it, Monday is the civil
Monday's
day?
civil, and
Tuesday and
Tuesday's
Thursdays.
criminal, but
Actually, it
exceptions
wasn't
can
that
be
long,
made.
I guess it was about a year and a half ago, just same thing. All right.
Judge, if I could just, before we start nailing down
Dates, yes.
And just so you know, the Commonwealth, we all met, and we hashed over a bunch of dates too, hoping that the court will find those dates for you. But having said that, briefly, I'm just going to say this. I didn't have the case for David.
I know, you came on board about a year ago,
I
right?
was in the middle of a double homicide when the case came up, and I really didn't look at anything for a few months. And when I say 27,000 pages, that's an underestimate. And included in some of that is video surveillance, hours of video surveillance. There's also transcripts of statements that still need to be properly transcribed in some instances. But aside from that, the forensic testing in this case
Thank you for mentioning that.
is extremely complicated, and it's still ongoing. And the Commonwealth and I, Attorney Porges, we're trying to work out an issue with the DNA testing and the exhaustive testing that is a very critical aspect of this case, and we expect to be able to, file a motion to address the issues we have. But the short story, judges, I hope the court understands. When we selected the dates for the proposed scheduling order, that was after we met a number of times. We talked about what the case was, our understanding of the case, and I want the court to know that we didn't suggest dates as a subterfuge to suggest, we'll just pick this.
And I don't think that anything I said in substance, or certainly in my intent, sometimes it gets lost in my translation and my delivery, was meant to suggest that that wasn't in the realm of possibility. I just think that it's probably not the best thing for the case. And I'm going to be here to try the case, whether it's in October or it's in April. But it's going to be tried in an efficient manner, and there's a reasonable view to, it's my pet peeve. I don't like serial motions to suppress. It's just as simple as that. But some people like serial motions to suppress. You don't know who you're getting on the other side of the bench. Some people like to take it in smaller tranches. I'm just telling you that I think there's a way to be more efficient. Of course, I'm not going to force or pressure anyone in this case within reason, and I'm never going to have to do it with counsel that I have here to make you do something that you're not comfortable going forward. I think we can be more efficient with the schedule, and I'm going to do my part to turn around the motions you do to present to me quickly.
And on the just now limiting to the issue of motions suppressing the dates, after the Commonwealth and I and Attorney Porges all talked, we think there is a need for 2 separate dates. And if we could, I would ask to come to sidebar to tell the court, to give you a reason that I'd like to do it at sidebar.
All right? How are you? Go back to that so that we'll seek the 10/20 date for impalement, and then we'll seek, I'm going to put you on the final pretrial conference. Let's do it 2 weeks out, because there might be enough instead of, I don't know what they normally do it here, it's usually the week before. But this one, we'll put it 2 weeks out.
Mr. Tippett and I can only start around 6 months out and keep you busy until then, so don't
Well,
be surprised if we keep it
I'll be watching. I'm just like, we'll be on the final stretch of motions eliminate. On, let's do it Tuesday, the 7th, is that right?
Yes, October 7th.
And then,
9 or 2.
I'm going to say 9.
I agree.
okay, so 9 a.m. for that, and that'll mean that you're going to have to back this out, but get your motions eliminated with any objections to me by the Friday before that. Earlier, if you can. If you can't, I'll just read them over the weekend.
So file everything by the 3rd, all motions eliminated by the 3rd.
Yes.
And any jury instructions, proposed voir dire, I don't know if you're going to want to do a questionnaire. If you do want to do a questionnaire, you can reach out to the court. I have a couple of ones that I've used recently in homicide cases, and I can give those to you. It does, in some ways, make the impalement, I don't know if it goes faster, but it raises issues in a more sensitive way.
I appreciate that, Judge. We've been working on a questionnaire already.
Okay, great.
I would appreciate anything. the court-
I'm happy to share them. They're available, and I think that every time you look at a different questionnaire, different issues come to light that you think might apply to your case, so I'm constantly tinkering with it. But I'll share a few that I've had in the last couple of years.
Thanks.
So, were you going to pick a date, give us a date for the filing of?
Everything's on that Friday before.
Okay.
Your Honor, if there are objections to anything that's filed on Friday, understand what the next written objection would be getting to you on.
Right. So what I was trying to build in was, and since I know that you work collaboratively, is I'd really like the whole package, like the 9A package, so to speak, together on that Friday before, so I can consider the objections, the oppositions. So if you can work collaboratively so that the oppositions are filed, maybe you give them to each other the week before. Your motions, if you want me to put that as a date, so initial motions eliminate are the Friday before, any oppositions are the Friday before the 10th.
Objections by the 3rd.
Yep.
file the week before.
So the 28th of September would be,
Right. Yeah, you've got by September 26th, you'll file all
Thank you.
motions eliminating any objections or oppositions filed by the 3rd.
That works for everybody?
yes, Your Honor.
All right. All right. Let's do, I think we agreed to 1-2 on the motions to suppress.
Your Honor, we need 2 tentative dates for the court.
Sure. Thank you.
For the first motion to suppress, which we believe, forgive me, will be evidentiary.
Yes.
We were suggesting April 7th. And then the following would be, for the remainder of the motions to suppress, May 12th. That would give counsel and myself 30 days to respond to anything that could come up.
Okay.
Especially if you had a decision, would have time, the counsel would have time, or you would have time to examine it.
So, hold on a second, I just need to check something. Give a calendar from Okay, 4/7 is a good date. That's on the evidentiary one?
Yes, Your Honor.
All right. I am not going to be here. I'm going to be close by in that quarter as well. So just stay tuned for a location. But it's going to likely be in Middlesex as well.
Yes, Your Honor.
147, right?
Yes.
Yeah. And that's 9 a.m.?
Yes.
Yeah. Okay.
And then 5/12. I can do that. I have to move something around, but I can do that. 9 a.m. also?
Yes, Your Honor.
Also Middlesex?
Yes.
Thank you, Your Honor.
All right. Dates on the motion to dismiss.
So, Your Honor, I haven't talked to Mr. Tipton and Ms. Borges about this, but I don't know how they feel about July.
It's fine.
So, July 14th, it's kind of smack in the middle of it. It's Monday.
All right.
Again, 9 a.m.?
Yes.
Yes, please.
Um, just stay tuned for where that's going to be.
Oh, yes, sure.
But I'll try to get up there. So you don't have to be where I'm going to be.
Thank you.
All right? Any other dates we need to put on?
We have a potential motion about the DNA testing, Your Honor.
What is going on with DNA testing? How long has the lab had it? What needs to be done? What has been done?
So the lab has tested samples from objects taken from garbage that was located outside the defendant's mother's apartment building. It's also tested samples from inside the family home in Cohasset. What is at Bodie right now is tissue that was found on a saw in the garbage at the mother's apartment building. That can't be done by our state lab. Essentially, these items put in a wax paraffin block, and Bodie has the ability to take slices from the block and do DNA testing from that. There are 6 samples that have the potential of having results. And so where we're at is that they have the potential of also being destructive testing at Bodie. And so that's where we're at as far as potential motion. Bodie has a different, and Mr. Tipping can probably speak to this better than I can, has a different policy and procedure for outside experts coming in and doing their testing. And also, there's a cost. And Mr. Tipping and I have been talking about the cost. And it has to get paid one way or the other. The question is who's going to pay it? Is the government going to pay for all of it? And so we're trying to figure that out, and that might be the subject of the motion.
Okay. Anything you want to add to that, right?
So the money issue will be resolved. I mean, they want $20,000 just to have someone stand there and watch. However, The real issue for us is the observation and what Bodie requires and limits any observer to see as compared to domestic police and some other ones. So we anticipate filing a motion, we discussed it with the Commonwealth, arguing that Bodie needs to at least change their protocols for this case, especially given the gravity of this evidence that's being examined. And we'll file a motion, and that's the two issues. The cost, which probably is not much to talk about, it's the other one that needs to be addressed.
Okay. When can we tee that up?
I think we can probably do it on that same January date.
Yeah.
On the 8th, because I don't think it's going to, I think I'll file something I can rest on the pleadings and we'll just need to release it.
All right, let's do it then.
Yes, Your Honor.
Two of you work together with regard to when it's going to be filed and give each other enough time, obviously, to propose.
Yes, Your Honor.
All right, any other dates we need to set?
The only other thing is a discovery date, but I guess maybe we should wait and see. I know there's two at least. There's other production of discoveries coming. I think when we come back, on January 7th, we look at a realistic findings.
All right, that makes sense, Joe, and I think you'll have the benefit of my ruling at that point and know what additional I think you ought to be producing.
Yes, Your Honor.
The addition of that motion, does that change the Zoom option for January 8th?
It doesn't in my mind. If you feel differently, let me know.
I was intending on being there, but I know...
You're welcome. All of you are always welcome, wherever we are. But if it becomes an issue that we would have to cancel the hearing versus doing it on Zoom, then it would be my strong preference to do it on Zoom. So you have that option. Just let the clerk know what you're doing. And obviously, it does create, obviously, some problems if defense counsel is on Zoom and the defendant had a number of issues with facility not putting them on, and then it gets delayed. And so sometimes if there's two counsel, one will come up and the other will be on Zoom. Just work to make sure that everybody's coordinated so we don't lose the date.
Yes,
And or have the defendant transported to Middlesex and nobody's there. I'm sure that won't happen, but given that there's some moving parts, I'm going to just alert you to the prospect.
Now that you've said you're sure it won't happen,
All right. So I'll see you all on the 8th. Before we close, is there anything anyone else wants to raise that I did not raise?
Yes. Is a housekeeping matter about the protective order?
Oh, yes, Your Honor. We submitted 2 protective orders. They're agreed upon without prejudice, but it relates to internal affairs discovery and potential bias that we've identified.
Okay. Let's take a look at them.
Yes, Your Honor.
I'm having to request those orders.
Thank you, Your Honor.
Thank you for that.
And counsel will receive those materials.
All right. Excellent. Thank you all.
Order, all right.
See you in January.
Thank you.
Goodbye.